Hello, everyone. Welcome to the third EU-Asia Aviation Law Forum. Good afternoon to our audience in Asia, and good morning to our audience in Europe. I don't think there's anyone from North America. You can go back to sleep. My name is Jae-Woon Lee. I'm an associate professor in the Faculty of Law at the Chinese University of Hong Kong, also known as CUHK Law. The event is jointly organized by CUHK Law's Center for Comparative and Transnational Law and Center for Commercial Law Studies at Queen Mary University of London. So the EU-Asia Aviation Law Forum started in 2022 after discussion with Dr. Antigoni Lykotrafiti from Queen Mary University of London. We believe that it would be meaningful to have a regular forum for engaging in debates on aviation law issues in the EU and Asia. The first topic in 2022 was the ASEAN-EU Comprehensive Air Transport Agreement. And the second topic in 2023 was aviation law and aeropolitical implication of the ongoing conflict in Ukraine. This is our third edition, and the title of our forum is Air Passenger Rights in the EU and Asia. Over the last 2 decades, air passenger protection regulations have received a lot of attention. In 2004, the European Union adopted EU Regulation 261, which deals with compensation and assistance to passengers who are denied boarding or whose flight is canceled or significantly delayed. More and more states have adopted similar passenger protection rules, and several Asian states are expected to do the same in the near future. So this third EU-Asia Aviation Law Forum will examine the origin and development of air passenger protection regulation. Now, let me briefly outline the structure of today's forum. So we have 3 speakers in this forum, and each speaker will speak about 15 to 20 minutes. After the presentation, we'll have an internal discussion for about 10 minutes, followed by 15 to 20-minute Q&A sessions. So if you have any question, please leave them in the chatting box. Now, briefly again, let me introduce the speaker. Our first speaker is Dr. Antigoni Lykotrafiti. Antigoni is a senior lecturer in transport, energy, and law at the Center for Commercial Law Studies at Queen Mary University, London. Prior to joining Queen Mary, Antigoni worked for the OECD on transport policy issues. She was prior to do that, she was an assistant professor at Tilburg University, Jean Monnet postdoctoral fellow at European University Institute, and a practitioner in the leading law firm. Her specialization include European and international law, and law in economics, and law in innovation as applied to the aviation sector. Our second speaker is Professor Lalin Kovudhikulrungsri from Thammasat University. I hope I'm pronouncing it right, Lalin. Lalin pursued studies at Thammasat University, Institute of Air and Space Law, McGill University, and the International Institute for Air and Space Law, Leiden University, for her PhD. Her doctoral thesis is about the right to travel by air of persons with disability. And at Thammasat, she teaches air and space law, public international law, and disability law. So I'll be the third speaker. I teach and conduct research on aviation law and competition law at CUHK Law. So right, ladies and gentlemen, so without further ado, we are now ready for takeoff. So first speaker, Antigoni, will address on EU 261. Over to you, Antigoni.
Thank you, June, very much. And let me share my screen. Can you see my slides? Yes?
Yes.
Excellent. Okay, so good morning if you are in London, good afternoon if you are in Asia, hello if you are somewhere else, and welcome to today's webinar. A warm welcome also from the Center for Commercial Law Studies at Queen Mary University, where I come from. It's the building that you see in the picture, a very special place where we teach our research on pretty much everything, including aviation. So, as June mentioned, my task today is to say a few things about air passenger rights in the European Union. I admit that this is not my favorite topic. You know, air passenger rights, the way I understand it, is to aviation law what criminal law is to law. everybody has an opinion about it. Everybody has an opinion about criminal law. Everybody has an opinion about air passenger rights. Maybe because people can relate to these subjects, or maybe because they are accessible. What I have observed, however, over the years is a discrepancy between what aviation experts argue in their publications on EU law and air passenger rights, and there is a wealthy of there are tons and tons of papers on air passenger rights out there. Aviation experts are quite critical of EU law and air passenger rights, whereas non-aviation experts, for example, experts coming from the area of consumer protection, they are much more positive, if not very positive. Now, I am submitting this observation for what it's worth, but I will reserve my judgment as to why there is this discrepancy. And I will plunge right in. I have on the slides the main legal basis that we have in EU law on air passenger rights. The first time the European Union regulated air passenger rights was in 1991, when it adopted a regulation on denied boarding. Denied boarding is something that you may be familiar with. Usually airlines deny boarding when they overbook the flights. Now, overbooking is not illegal. It is not prohibited by law, and the airlines may sell the same seats twice, basically, because the profitability margin in the industry is very thin, and the airlines have proven that there is a percentage of no-shows per flight. So even though there are passengers who have purchased their tickets, they do not show up. And in order for the seat not to go unoccupied, what the airlines may do is overbook the flight, so sell the same seat twice. And so if both passengers appear and ask to board, one of them will be denied boarding. At the time, in 1991, the EU adopted a regulation obliging airlines to offer compensation to passengers who were bumped. I will fast forward now a little bit. We are in 1999 when the Montreal Convention was adopted. The Montreal Convention is an international convention. It regulates air carrier liability in the event of an accident or if there is a delay. So it regulates in a uniform fashion the air carrier's liability in international transportation. The European Union has signed and ratified the Montreal Convention because this convention is open to regional economic integration organizations to join. And so it is bound by it. And so what the European Union did in 2002, it adopted a regulation 889, which implements the Montreal Convention into EU law. So Montreal applies not only to international transportation, but also to intra-European transportation. And by this, I mean cabotage routes. So a route, for example, from Athens to Thessaloniki in Greece. So the Montreal Convention has provisions on delay, and the EU is bound by these provisions. In 2004, the EU adopted Regulation 261/2004, which is the law that applies at the moment, as we speak, on air passenger rights. This is the main legal basis we have in EU law on air passenger rights. In the event of denied boarding, cancellation of a flight, and long delay. So you see that even though Montreal Convention has regulated delay in international transportation, in EU law there is a regulation that regulates also delay. And it comes as no surprise to me that this issue has been examined by the Court of Justice of the European Union. I will also say, before moving on to the regulation itself, I will also say that the EU has adopted a regulation on the rights of disabled persons and persons with reduced mobility when traveling by air. So if our mobility is reduced for any reason, pregnant woman, the elderly, somebody who has broken their leg and needs assistance at the airport or on board the aircraft, there is legislation in place. I will move on to Regulation 261/2004, which is very controversial. I will just say that it has been interpreted by the European Court, by the top court of the European Union, the Court of Justice, on at least 78 occasions. So we have 78 preliminary rulings on the right interpretation of Regulation 261, and this is telling. If you consider that it is a light instrument, so it counts 7.5 pages, and yet it has been interpreted so many times by the European Court of Justice. I have on the slide the main provisions that concern air passenger rights. So what happens if we are denied boarding, if our flight is cancelled, if our flight is delayed? What are our rights? So if we are denied boarding, we are entitled to compensation and our money back if we no longer want to fly, or if we still want to fly, we are entitled to rerouting, and we also have a right to care. And this means provision of meals and refreshments by the airline, accommodation if necessary, transportation from the airport to the hotel and back, and communication. And we also have a right to information. Already at check-in, we are informed of our rights. And if there is any disruption with our flights, the airline is obliged to supply us with a notice in writing, informing us of our entitlements. The European Commission has also developed an app that you can download on your smartphone. I have done it. I have it on my smartphone. And so if you travel from the European Union with either an EU airline or a non-EU airline to any destination, EU law applies. Or if you fly with an EU airline from a third country to an airport within the European Union, the EU law applies. Now, what if the flight is cancelled? What are our rights? Well, we are entitled to reimbursement, our money back. Or if we want to fly, we are entitled to rerouting. We can ask the airline to reroute us. And we are entitled to care, depending on how long we will have to wait at the airport to be rerouted. And we are entitled to compensation unless we were informed of the cancellation at least 2 weeks before the scheduled time of departure. So if the airline informs us 2 weeks in advance, we are not entitled to compensation. If the airline informs us of the cancellation less than 2 weeks in advance and reroutes us, and we reach our final destination within prescribed time frames, and this is all in the regulation, then we are entitled to compensation, but it will be slashed by 50%. And incidentally, the amounts that we can recover if our flight is cancelled are not so significant. So if a short-haul flight is cancelled, the maximum we can recover is 250 euros. If a medium-haul flight is cancelled, the maximum we can recover is 400 euros. If a long-haul flight is cancelled, the maximum we can recover is 600 euros. Now, the airline doesn't have the obligation to pay compensation if the flight is cancelled, if the cancellation is due to extraordinary circumstances, which could not have been avoided even if all reasonable measures had been taken. And now you understand that these extraordinary circumstances has caused a lot of interpretative headaches. What is an extraordinary circumstance? Bad weather. A hidden manufacturing defect, it qualifies as an extraordinary circumstance, but certainly not a mechanical problem with the aircraft, not a technical issue on the aircraft. This doesn't qualify as an extraordinary circumstance. If airport personnel is on strike, if air navigation service providers are on strike, this is an extraordinary circumstance. But if the airline's personnel is on strike, this does not qualify as an extraordinary circumstance. Now, what if our flight is delayed? If our flight is delayed, we are entitled to care. I'm just looking at the regulation. I'm just looking at the legal basis now. I see that we are entitled to care and our money back if the delay is longer than 5 hours. I don't see anything about rerouting, even though the airlines do reroute passengers if there are delays. I don't see anything on tarmac delay, which in my case is the worst form of delay. The worst thing that can happen to a passenger at the airport is to suffer a tarmac delay, especially if it is long. I don't see anything on cancellation. I don't see anything on cancellation. On compensation. Yet, the Court of Justice of the European Union in the Sturgeon preliminary ruling, which is one of the most controversial, if not the most controversial, preliminary ruling the Court of Justice of the European Union has issued on Regulation 261/2004. In this judgment, the court legislated a right to compensation if there is a delay longer than 3 hours. So the court read a right to compensation into Regulation 261, even though the regulation itself doesn't provide so. So you understand that this is one of the most controversial rulings of the Court of Justice. Another controversial ruling is IATA and Delpha. This is a case where the court was asked to pronounce on whether the regulation violates the Montreal Convention. Remember, both EU law, the EU regulation, and Montreal Convention 1999 regulate delay. So does EU law encroach upon international law? The EU is bound by the Montreal Convention. The court said there is no violation because the systems are not overlapping. They are seamless. They are complementary. Because the court said, I'm looking at the temporal scope of the Montreal Convention and it applies from embarkation to disembarkation. So it deals with individual damage caused to passengers on an individual basis. And I'm looking now at EU regulation and it operates before embarkation, first, and second, it compensates passengers for the inconvenience, for the irreversible loss of time. So the inconvenience is the irreversible loss of time, and it provides in an immediate and standardized manner assistance to passengers. So it doesn't deal with individual damage. Montreal Convention deals with individual damage that has to be assessed on a case-by-case basis. There is no overlap. The EU system operates at an earlier stage. Another controversial judgment is Valentin Herman, where the court had to decide whether a technical problem in an aircraft qualifies as an extraordinary circumstance that exonerates the airline from the obligation to pay compensation to passengers whose flights has been delayed due to the technical problems in the aircraft. And the court said, disregarding, I believe, the jurisprudence that we have on this issue under the Montreal Convention, the court found that the technical problem in an aircraft does not qualify as an extraordinary circumstance. It is not an extraordinary circumstance. It is inherent in the normal exercise of the activity of the airline. And if it is also beyond its actual control, so it is inherent in the commercial exercise of the air carrier, and it is within its actual control to foresee it, only if it is beyond its actual control to foresee such a technical problem, if there is sabotage, if there is a hidden manufacturing effect, if there is a terrorist attack. Only in this case, a technical problem in an aircraft can be an extraordinary circumstance. In all other cases, it is inherent, a technical problem in an aircraft, it is inherent in the normal exercise of the commercial activity of the air carrier, and the airline should expect such kind of problems. Finally, another more recent and very controversial ruling of the court is in the Wegener case. In this case, the court seems to have given extraterritorial effects to Regulation 261/2004. Here we had a flight from Berlin to Agadir in Morocco via Casablanca. So a connecting flight, one segment from Berlin airport to Casablanca airport, and another segment from Casablanca airport to Agadir. The airline was a non-EU airline, Royal Air Maroc. And what happened in this case is that there was a little delay at Berlin airport, but a short delay, and the passenger reached Casablanca airport on time, in good time, to catch the connecting flight. There was a change of aircraft at Casablanca airport. So the passenger presented herself for boarding, but Royal Air Maroc had reassigned her seats to another passenger, and so denied boarding basically, and rerouted the passenger, so put her on a later flight, and she reached her final destination, Agadir, with a delay, with a 4-hour delay. When she reached her final destination, she claimed compensation under Regulation 261. And Royal Air Maroc said, "I'm sorry, I'm not bound by the regulation." So the court had to decide whether EU law applies, and the court said, I see here a single reservation. There are two segments, but this is a single booking. I will see it as a whole. I will see this itinerary as a whole. It's a single transport operation. EU law provides that it applies to passengers departing from an EU airport. The passenger here departed from an EU airport. EU law applies. I'm not going to say more on that, but it seems that the court gave extraterritorial effect to EU law. And final slides, and I will hand over to June. As you have realized, EU law on air passenger rights, and especially Regulation 261/2004, has raised a lot of issues, one of them being its compatibility with Montreal Convention, given also the doctrine of exclusivity, which is provided for by Article 29 of the Montreal Convention. In fact, a lot of experts argue that the Montreal Convention is not only exclusive, but it is also exhaustive. I personally do not like the complexity of EU law on air passenger rights, in particular the complexity that 261/2004. That the system the complexity of the system that Regulation 261/2004 has put in place. There is a litigation frenzy. I mentioned already that the Court of Justice of the European Union has been seized on at least 78 occasions to interpret the regulation. I find the system also very time-consuming. Our time has an opportunity cost to claim. For passengers to claim their entitlements, they have to spend hours and hours filling in online forms, communicating with airlines. Airlines have all sorts of tactics to fob off passengers, to frustrate passengers. They lie. They never say the reason for the cancellation. So this has provided fertile ground for what I call a parasitic ecosystem to grow. This is, of course, a very provocative view. So what we have is claims management companies and online law firms. So the passengers, rather than going online and trying to fill in forms and deal with the airline directly, and then with alternative dispute resolution bodies and with national enforcement agencies, etc., what they do, they just ask claims management companies or online law firms to represent them. And these operate on a no-win, no-fees basis, but they deduct, if they win the case, they deduct more than 50% of the compensation, which is granted to the passenger by the airline. So the maximum you can recover under the regulation is 600 euros. If the solicitors deduct more than 50%, then you are left with less than 300 euros. somebody, of course, can approach differently this innovative business model that has popped up based on low value and high volume claims as facilitating access to justice. So up to you how to approach this. And last word from me, given that EU law on air passenger rights seems to have a Brussels effect. So now there are over 60 jurisdictions that have air passenger legislation, that have adopted legislation on air passenger rights. And some laws are modeled on EU law on air passenger rights. I'm wondering whether the EU, if it wanted to change the system radically, because you see in 2013, there was a proposal, the European Commission came up with a proposal for an amendment of the regulation, which however has not been adopted. So I'm wondering if the EU wanted to go for an overhaul, not for an incremental improvement of the current system, which is what the proposal basically suggested. Could it do it now that EU law seems to be spreading outside its borders? So thank you very much, and I will hand over now to June.
Okay, thank you, Antigoni. I thank you for setting the
Thank you.
tone. And I have a couple of questions, but let's talk about it after our presentation. So now the second speaker, Lalin. So she will talk about the development in Thailand as well as ASEAN countries. Over to you, Lalin.
Thanks, June and Antigoni, for your very interesting presentation. Let me share my screen. Okay. So hello, everyone, across the time zone. I hope you hear me clearly. And it's great to see so many people interested in these issues. Today, I would like to speak about the air passenger rights in Southeast Asia country. And with focusing on Thailand, the sequence will first be an overview of the ASEAN air passenger market, and then a brief overview of each ASEAN member state position on the air passenger rights law. And then I will present a comparative aspect and then focus on Thailand's example. And as Antigoni mentioned about the Brussels effect. So during my presentation, maybe some of you can notice whether ASEAN member state, how the Brussels effect impact on each ASEAN member state, and then we can discuss about that even maybe during the Q&A session. So according to the Asian Development Bank data, before the COVID-19 pandemic, Southeast Asia air travel market is quite huge. It exceeded 500 million passengers, and this representing around 11% of the global air traffic. And on the pie chart, I show you the share ratio of each ASEAN member country. The data is from ASEAN Stat Organization. And after the pandemic, with the borders reopening and recovery is ongoing, and the full pre-pandemic passenger level is expected to be resumed by next year. So with the resume of passenger, the flight disruption such as delay, denied boarding, and or cancellation may be unavoidable. And the question is, which legal protections are available to passengers who travel within this region? And in case of 10 ASEAN member states, the protection is varied. Even though we also have the regional integration, ASEAN is unlike EU. We do not have the parliament, we do not have the court of justice. So each country still has the sovereign in terms of the legislations and other sovereign branches as well. So the protection in terms of air passenger rights is varied. And as Antigoni mentioned first about the Warsaw and Montreal regime, you can see the varied because Thailand never ratified the Warsaw Convention of 1929. For the Montreal Convention, Laos and Myanmar have not yet ratified. And if we look at the domestic law on air passenger rights, we can divide into two groups. And each group consists of 5 member states each, so it's equal. The country with the orange color, Indonesia, Malaysia, Philippines, Thailand, and Vietnam, are those countries which have their own domestic law on passenger rights. And the other group does not have their own specific law. Singapore is in the latter group. So it is not conclusive that the major aviation hub countries in this region has specific law on air passenger rights. And with this information, I will not neglect the discussion of Singapore because it's a major aviation hub in this region. And from the review of the Civil Aviation Authority of Singapore, the CAA of Singapore tends to work on the awareness raising instead of the legislation. And with that, I look into the airline webpage. So on each airline webpage, they will have one page devoted to the passenger rights, and they describe how they will protect in case of any flight disruptions. So the protection measures are varied, depend on the airline, and also depend on the route that the airline fly to. So if they fly to the EU or flying back from the EU, they may be covered by the EU 261. And within that, the airline website, they even mention tarmac delay, which is the US law. So this is how Singapore deals, or say the airline in Singapore do. So we move to the other group of countries that have specific law. For Indonesia, the Ministers of Transport Regulation 89 of 2015 regulate on the air passenger rights, but it covers only the domestic flights, and they specify 5 categories of delay. And the last one, that in case of the delay for more than 4 hours, they will provide a fixed monetary compensation. But in this regulation, it does not mention the time for the passenger to bring the case to the court. So there's no limitation period mentioned in the Indonesian law. Now we move to Malaysia. And in my opinion, I think Malaysian law is quite advanced and comprehensive within this region, at least, because the Malaysian published its Malaysian Aviation Consumer Protection Code, and its contents cover not only the air passenger rights similar to the EU 261, but also regulate the passenger with disabilities issues. But in case of the EU, as Antigoni mentioned in her slide, that it's in the EU 1107. But in case of Malaysian code, it's covered in the same code. And for the delay, Malaysia does not fix the amount of compensation, but rely on the Montreal regime. So the liability for the airline damage, in case of any damage or flight delay, it will be governed by the Warsaw-Montreal regime, the international law one. So that's why I think it's quite comprehensive and advanced. Now we move further north from Malaysia to the Philippines. The Philippines also has their passenger bill of rights around the same period, 2012. This bill of rights covers both domestic and international flights. The contents extend its scope to baggage as well, and also cover the tarmac delay, which I think it's maybe an influence from the US law. And similar to the Indonesia case, the Philippines Bill of Rights provide compensation for terminal delay for more than 6 hours. And again, no limitation period mentioned in the Bill of Rights. And we see the same trend in the Vietnamese law in 2015 as well, because Vietnamese law also regulates domestic and international flight, provide a fixed amount of compensation for long delay of flight, and no limitation period for bringing. It does not stipulate the time, the limitation period. And Vietnamese law also obliges the passenger to provide accurate information on the method of compensation so that they can reimburse to the correct person. And now we move to my home base country, Thailand. Thailand has a unique case because we have two pieces of legislation. First, we try to govern only domestic scheduled flight within Thailand. However, we have the case that the charter airline when they flew to Korea, but in the end they cannot fly back to Thailand because of their financial problem. So the airport authority did not allow the airline to fly back. So in this case, after this case, the Thai regulator passed the law to protect air passenger who travel international flight, but only on charter flight. So at this moment, Thailand does not have any law to protect international passenger flight. And for domestic scheduled flight, we also provide compensation for flight delay for more than 5 hours and no limitation period written in its announcement as well. So with this, just a quick summary. Among the 5 states which has the specific law, you can see the varieties because the scope are different. And on the third column from the left, I mentioned the Luxembourg effect in addition to the Brazil effect. But for the Luxembourg effect, I would like you to focus on the sturgeon case because in case of EU 261, as Antigoni nicely mentioned that the CJEU legislate the law. So these ASEAN countries, 4 out of 5 countries, they put what the court reasoned and put it into the black letter into their domestic law. So that's why the sturgeon or Luxembourg effect was impact. This is how it's impact for ASEAN countries, except Malaysia. But for the limitation period, even though the CJEU correctly decide in the case of MOR versus KLM, that the limitation period is depend on each member state national law, Indonesia, Philippines, Thailand, and Vietnam do not mention the limitation period in its own regulation. Only Malaysia provide 1 year, and I check that there's the plan to revise the limitation period to be 2 years to be in line with the limitation period under the Montreal Convention. Thailand does not have a chance to revise the law, but the court has the case and the court opt for the 2 years limitation period, similar to the Montreal Convention. And with this different scope, I would like to draw attention to the example of, this is the very recent case happens in Thailand just like a few weeks ago. This is the case of Air Japan. Air Japan is the low-cost carrier from Bangkok to Narita, Japan. However, there are some technical issues for the flight. So at first, the staff declared that the flight would be delayed, but in the end, the flight has to be canceled. And the problem is, Air Japan has only 1 available aircraft, so the flight has to be canceled, not only 1 flight, but also 4 consecutive flights. And because, as I mentioned earlier, that Thailand does not have any law on international air passenger protection, neither does Japan, which is the destination. So what the Thai authority can do is just call for the meeting as shown in the photo. So the Civil Aviation Authority asked the Air Japan executive for their protective measures. And they also, the authority also warned the airline operator that the authority has the power to suspend the license if something like this happen again in the future. It seems that the authority is very active. However, the passengers who experience the flight cancellation does not even have the right to be informed, does not even have the right to know their right, if any, during the flight disruption. This is because there's no specific law to govern on these issues. And because of these issues, and not only because of this issue, but actually Thailand is now under the hearing process of our new laws to protect the air passenger rights. So the QR code that I show on the screens is the link, is the QR code that you can access to the draft bill on the air passenger rights in Thailand. And again, 2 QR codes because we separate the scope of application, one for the scheduled flight and the other for the charter flight. The information is available in English, so feel free to access and comment on the issues. Thank you very much, and thank you for your attention.
Thank you, Lalin. But before I start, just one minor question. So in this, the last example you showed, Air Japan one, I'm guessing it's still Montreal Convention apply, but what you're saying is there's no right to information in this circumstance, correct?
Yes. From the route from Bangkok to Japan, of course, Montreal Convention apply, but this case is the cancellation. So actually, it's cancellation is out of the scope of the Montreal Convention. If we can say like that, because it doesn't operate as well.
Okay. Thank you. All right, so it's my turn now. So I'm going to share my slide. Can you see my slide? Okay, great. All right, so I'm going to talk about air passenger protection regime in Hong Kong. I'm based in Hong Kong. This talk is based on my co-author article. I worked with my friend Victor Chan. So those who are interested in this article, let me know. I can send it. So this one, for the next 15 minutes, the way I'll do is I'll give you some overview. Then we'll talk about Hong Kong agencies, our agency related to passenger protection. And then I will point out the lack of passenger protection rules in Hong Kong. Then some of the issues arising from COVID-19, and the lessons from other countries. In here, I'll talk about Korea. I mean, I'm from Korea, and also a little bit about US. Then Mike will also make concluding remark. So I think starting point is as follows. I believe that the fact that a certain country has enacted an aviation-specific consumer protection law, it doesn't necessarily mean that system is better than those without specific law. So what I'm trying to say is that passenger protection law can be regulated by broad consumer protection law. Passenger protection law can be regulated by contract of carriage if it is working well. So that's my starting point. You may have a different idea, but my view is that the simple fact that you have a law doesn't mean you're better or worse. So the important is how it works. So broadly speaking, I think there are 2 factors we need to think about for this topic. The reason why we have so many passenger protection law around the world is because for two reasons, in my view. One is, broadly speaking, from the beginning of the 21st centuries, individuals realize that they're more aware of consumer protection regime. So individual consumer became more smart. They want to know their own right. They want to claim their own right. That's one broad picture. The other one is dissatisfaction with Montreal Convention. I mean, we know that Montreal Convention has been very successful in aviation, the world, and for cargo, passenger, baggage, relatively working well. But one thing that people may find very unhappy is the area of passenger delay, because under Article 19, the passenger can get compensation in case of delay, but then quantum of damage, expected damage they can get, is very low because most courts do not recognize emotional harm. So only economic damage will be compensated. If you think about economic damage in case of delay, it's not many things that can be compensable. So, okay, hotel accommodation or taxi fee, the loss of your day for salary. But that's the success if you win the litigation. So this lengthy litigation, also expected outcome after Montreal Convention case, that kind is really deter the passenger go against the airline. So passengers are not happy with compensation regime in Montreal Convention on delay. So with that, I think this really was a push factor to make compensation, actually passenger protection law around the world. But as far as Hong Kong is concerned, I want to start by saying Hong Kong has neither aviation-specific consumer law, nor has just comprehensive law covers all passenger protection. In other words, as far as the law is concerned, there's no specific law dealing with passenger protection. And another thing I want to start by saying is there are multiple government agencies involving passenger protection that created some kind of confusion, which I'll point out later. So from a passenger perspective, it's not quite clear which law will be applicable, which law have been infringed, and what recourse is available, and what government agency is responsible for this issue. So I'll briefly talk about agencies related to passenger protection. Again, I will not go into too much detail. So these are the list of government agency related to passenger protection broadly. So TLB, Transport Logistics Bureau, is in charge of transport policy, so a broad government body. Very often, the passengers, no, not very often, it's not the right word. Sometimes passenger contacted TLB, and TLB make it very clear this matter is up to contract, not by the law. And they often refer the case to consumer counsel. So the CAD, Civil Aviation Department, is mainly responsible for aviation safety issues. So they, technically speaking, they don't have scope in regulating passenger protection. ATLA, Air Transport Licensing Authority, they are the one who give a license, check the legitimacy of airlines operator certificate. Consumer Council is interesting. So Hong Kong does have a Consumer Council, but it doesn't have enforcement power. It doesn't have the investigation power. So what they do is they post it on their website and they advise government on passenger consumer protection related issue. So, and then lastly, there's a unique custom and excise department. I'll explain why CNED is involved in this issue. So this table, I collected this data up to 2017. This is some data presented at the Hong Kong Legislative Council. And then after 2017, me and my research assistant, contacted the relevant government body for the kind of to make this table more comprehensive. So this is data about the number of complaints related to passengers of airline unable to board scheduled flight. So you see that many passengers try to reach out different government bodies. So total, I'm not saying the number of complaints is so many. Many of them maybe probably have contacted airline first, but for government body, there are some spreading out. So maybe it's because they don't know where to contact. So here, a little bit talk about the law part, I would say lack of passenger protection rules. So starting point, legal principle, the government made it very clear, overbooking and denied boarding in Hong Kong are considered a kind of commercial activity. So it needs to be governed by contract of carriage between airline and relevant passenger. So there's no law on this issue. And one relevant law is the Trade Description Ordinance, I call it TDO. The TDO prohibit the false trade description and other relevant unfair trade practices. I'll explain why it can be related to the topic that we're discussing. So in a nutshell, if passengers suffer some loss, some damage as a result of overbooking and denied boarding, an aggrieved passenger can make a civil claim on the airline. But it's quite easy defense for airline. The easy defense is that as long as airline provide alternative flight for the passenger, then it's not compensable delay, compensable damage under the law. So if you think about it, in the denied boarding cancellation, most of the time airline provide alternative transport. I think the one Lalin described very exceptional, but most airlines, of course, are able to provide alternative flights. So as long as you provide alternative flight, done deal. It's not the infringement of the TDO. This one, I'm not going into too much detail. If you want to know more about Hong Kong law, again, I'll send the article. But just broadly speaking, back to the defense part. As long as the airlines provide alternative flight, it's very difficult to be caught by this law. Then a little bit about COVID-19, how COVID-19 affected Hong Kong scene, and not only Hong Kong, the whole around the world. I must say that during the COVID-19 crisis, the important factor is not really about passenger protection. It's more about how to survive airline industry. So, for example, EU announced it from the very beginning. Antigoni mentioned that as long as the airline canceled the flight with a 2-week notice, that's not cancellation under Article 2261. So most airlines were able to cancel the flight with a 2 weeks notice. Those who have to cancel within the 2 weeks, they can still rely on extraordinary circumstances because not by them, it's but by the government. So what was important though during the time, it left the mark of uncertainty of passenger protection policies because there's so much confusion which law be applicable. So the passenger were stuck in the other parts of the world. Will they get compensation for hotel? Because looking at the other countries that have passenger protection law, although you may not get compensation, some accommodation, right to care could be provided. But this was a lot of confusion during COVID-19. So something I want to emphasize, the lesson, as I call it, lesson from the other countries. I'm not saying these countries are sort of best practice, but it's something that we can think about. So I'll use Korea first, my home country. The Korea Aviation Business Act, and previously the Simple Aviation Act, and 2016, they divided into 3 different acts. And in the Aviation Business Act, there are relevant articles. So here, Article 60 said the airline must have passenger damage relief plan. So you must have your own plan. Airline must have it, and then you need that plan must be easily accessible. That's by law. So you need to provide this information by website or at the check-in counter, and also there'll be some kind of assessment of service. So why is it important? I think it can play as a naming shaming effect. So they will list up which airline is doing well, which airline is not doing well, and they publish it so that consumer can understand which airline is very good at consumer service, which airline is not. And actually, to follow up, even that factor can be used for slot allocation and traffic rights allocation. So the performance of airline can be factored in, can be considered by regulator when they allocate slot and allocate the traffic right. And one of the business acts, the airline must set up the damage compensation plan. Among them, these are the list of things they need to specify: the cancellation, overbooking, delay, and sometimes delay payment when you pay in case of cancellation. And right to information, and also it's really important. So airlines and travel agency must notify passenger by phone and text message or KakaoTalk in Korea. Then you need to constantly update them what's happening. So in case of delay, cancellation, each by law, you need to provide relevant information. And there's the tarmac delay clause. No aircraft carrying passenger may sit on tarmac for more than 3 hours. And also, airline has to inform the consumer dispute resolution standard. What it is this is not if you look at this table, you may think that, wow, quite similar to EU. So certain amount of, some certain time of delay, then you will get some kind of compensation. But this is not law. This is not regulation. This is sort of standard. So government saying that for domestic flight, around this 1 to 3 hour delay, then the passengers are entitled to have 20% of the fare, the 20% of the ticket. This is also interesting things. If you think about the EU 61, they don't differentiate the types of ticket you purchase. The first class passenger, economy class passenger, the passenger you bought it maybe €1, and then you're still entitled to get €600. So they don't differentiate amount of money they put, but here they look at the money you put. So they based on their fare, they can get compensation. And they differentiate domestic, international. So these are the sort of guideline, and airlines are supposed to provide this based on the standard. But one of the things I need to emphasize here is that airlines can defend themselves by arguing this is the cause of a delay is force measures. So force measure, they include natural disaster, weather related, and aircraft rotation, but really importantly, unscheduled maintenance. So we talked about the Lalin case. I think Antigoni talked about how EU court interpreted the mechanical related delay. So it kind of put the bar really high. So normal maintenance related delay cannot be defended. So it has to be more than that, some hidden manufacturer effect. Other than that, you can't really defend yourself. But Korean law, the threshold is not that high. So as long as the airline can prove that it is unscheduled maintenance for ensuring safety operation, then it will be falling under force majeure. In other words, easier for airline to defend themselves. I'll talk a little bit about US. So for the consumer complaint, I think this is a really important one. US DOT, Department of Transportation, require airline to acknowledge the consumer complaint. You think about it, if you are passenger and you send a complaint to the airline, then what makes you really frustrated is that there's no reply. Did you get my complaint? Did you get my email? Very often there's no system on it. But here, the airline must acknowledge consumer complaint within 30 days receiving date. I think 30 days might be too long, but anyway, there's an obligation on it. And then you need to address it with an answer within 60 days. So also you're requiring, this kind of communication transparency is important to mitigate your anger. And for flight delay cancellation, similar to Korea, airlines are not required to compensate passenger when flights are delayed, canceled. So by law, there's nothing like that, nothing like 261. But airlines are required to provide information. So that's by law. And for bumping, so the United put it differently, and oversell the denied boarding basically. And airline, DOT, government require airline to give all passengers who are bumped involuntarily with a written statement. So this kind of what's your right? So tell them that these are your right in case of denied boarding. And similar to Korea, one thing I want to emphasize, they also publish air travel consumer report. So this naming shaming effect is important because airlines have motivation to be better by keeping their reputational image. To avoid reputational damage. So the final thought. I think looking at Hong Kong, so I've been here for 7 years. I've been teaching aviation law in Hong Kong. So in a way, the level of passenger service at Hong Kong airport, I think I would say good. Overall, it's good, but it doesn't mean it's perfect. But as an aviation hub, I think that more research is necessary to review whether passenger protection law is needed in Hong Kong. Right now, it's more about do we have to do it or not? So I think at least we need some additional research to see that whether we have specific protection law, consumer protection law in Hong Kong. And I emphasize that the disclosure of information, more guidance on disclosure of compensation arrangement for overbooking and cancellation is necessary. So very often it's not about what you get, it's about how you communicate. So really important that some guidance is required. Final thought, as I emphasized in the beginning, there are several agencies working on broadly passenger protection. It would be much more preferable to establish some single channel for that passenger in case when they face the long delay, cancellation, deny boarding, some kind of agency that you can go as a single channel. So with that, I conclude my presentation and thank you for your attention. Okay, I think we are on the right track because I was hoping that we finish our presentation within 1 hour. So we always on time performance. So let me start asking some questions to Antigoni. So let's start with the very first one. So you talked about extraterritorial jurisdiction. So using Wagner case, so like you pointed out, it happens outside of EU, done by non-European carriers, but yet EU court view that EU law still apply if you interpret 261 in a strict manner. Can you just share your overview on this extraterritorial jurisdiction approach by European court? Because it's a big question, I understand, but it is controversial question. So can you share your view on it?
Yes. You know, it is not the first time that the Court of Justice of the European Union gave extraterritorial effects to regional law, to EU law, which is regional law. I will remind you of the EU emissions trading scheme and the decision of the European Union at some point to subject international aviation to the EU emissions trading scheme. So as of the 1st of January 2012, the idea was that international airlines would be subject to the EU emissions trading scheme. So an American airline, in other words, taking off from LA, overflying the United States, overflying the Atlantic, and landing at Heathrow Airport would have to monitor its emissions from takeoff from LA all the way to London and report to a UK authority. The UK was at the time a member state of the European Union, and pay for its emissions, pay for its carbon emissions. And you understand that there was an outrage, and the European Union was obliged to take back that measure, so to suspend the application of the scheme to international airlines. However, the Court of Justice of the European Union had been asked to pronounce on whether this measure of the European Union that gave extraterritorial effect to EU law was compatible with international law, with treaty law, with customary international law. And the court said, well, no, there is no violation of international treaty law, no violation of the Chicago Convention, no violation of customary law either. So it's not the first time. This case, Wegener and Royal Air Morocco, was not the first time when the court gave extraterritorial effect to regional law. And this is one of the problems, I think. Here, I don't think the court, in the Wegener case, I don't think the court paid due attention to the facts of the case. Because basically, yes, there was a short delay at Berlin airport, but the passenger arrived at Casablanca airport where she had the connection in time to catch the flight. And she presented herself for boarding. And she was denied boarding there. And there was a delay, and they rerouted her. The court didn't pay attention to the fact that basically what we have here is denied boarding outside the European Union, right?
By non-European carriers.
That's right, and even if an EU airline operated the flight from Casablanca to Agadir, EU law wouldn't apply because EU law provides that it applies to passengers who depart from the EU or who fly with an EU airline from a third country to Europe. Here we have a flight outside the European Union entirely, right? So Casablanca, Agadir. This is a cabotage route, but the court saw this flight, saw the itinerary, so as a single transport operation, and said, I cannot fragment. I see a single booking here. The passenger booked once, did the check-in once, departed from an EU airport, EU law applies. So this is the perspective of the court. As I said, it didn't pay due attention to the facts of the case. This is my view.
Okay. So, by the way, after having internal discussion, we are going to take the question from you. So I see the question coming up. So, but before moving on to our Q&A session, I have a couple of questions to the Lalin and Antigoni more. So, Lalin, my question is, in ASEAN, not ASEAN, the ASEAN region, so there are harmonization approaches in the various sectors. So I think what I know is that e-commerce sector, for example, they do some harmonization. Do you see any attempt in this area, passenger protection law, any kind of harmonization attempt?
Because air passenger protection is a combination of aviation law and the consumer protection law. And in ASEAN, the air transport sector try to let the consumer protection sector responsible for the air passenger rights as well. So at this moment, sadly, I have to say that there's no action from the ASEAN level yet. However, I do hope that at least in the aviation sector at the ASEAN level, at least they may say something similar to the ICAO core principles, that at least you should enact your national law, not contradict with the Montreal Convention. I hope.
Yeah. And one thing I see from your slide is that the country with a big domestic market are establishing the passenger protection law. So you talked about Vietnam, Indonesia, the Philippines, Thailand, Malaysia. These are the ones who have a bigger domestic market. So I guess that there are some need for legislator or politician to suggest some law dealing with domestic air travel.
Exactly. And in case of Thailand, at least, first, we try to govern only domestic flight. But after the incident, the very exceptional one, as I mentioned, that's why the politicians were forced by public that you need the law for the international charter flight. And the reason that now we propose the law for international flight is because of the public, the social media say that people get angry with the flight cancellation and the things, especially during the COVID disruption. So that's why.
But to me, it's a bit interesting to see that you have a special law for international flight, for charter flight.
Yeah.
Okay. So question to both, because as you know, EU ASEAN recently signed the EU ASEAN Comprehensive Air Transport Agreement, and in that agreement there is a passenger protection law. I forgot the name of title, but it deals with this issue. Do you have any thought on it?
Consumer protection.
Yeah, Antigoni, can you start?
Indeed, there is a provision on consumer protection in the ASEAN-EU Comprehensive Air Transport Agreement. It's not the first time that in an EU-type air transport agreement we see a provision on consumer protection. The first time we saw such a clause was, I believe, in the US-EU Air Transport Agreement, and then in the Canada-EU Air Transport Agreement. In 2021, in the Qatar-EU Air Transport Agreement, Comprehensive Air Transport Agreement, there was a provision on consumer protection. And finally, in 2022, we had the ASEAN-EU Comprehensive Air Transport Agreement, and there is a provision on consumer protection. Now, these provisions belong to a new generation of provisions that you have in EU-type comprehensive air transport agreements, which concern regulatory cooperation. And the wording of these provisions is hortatory. The wording is hortatory. However, if you see the latest agreements, especially the one with ASEAN, the agreement is not open to private enforcement. Only the parties can invoke them. And the joint committee, there's a joint committee that has been established by these agreements with the mandate to implement them. So the agreement, the ASEAN-EU air transport agreement cannot be invoked by private parties. So there is no room is left for private enforcement. Only the signatories can invoke the agreements. If they have a problem, they can arbitrate or they can go to the International Court of Justice. But there's a joint committee in place with the mandate to implement them. And so they have, they meet regularly, they have a structured dialogue, stakeholders are invited, and they try to reach regulatory convergence on issues of environment, consumer protection, and other issues. So it is within the parties, and as I said, it is the joint committee, the body that has been established for paving the way for regulatory convergence on consumer protection. And perhaps we will see some hardening of the hortatory language of these provisions into binding law, into binding. So I believe that these provisions will harden over time. They are hortatory as they stand, but over time, I believe they will harden, right?
Okay. Yeah. So question to Lalin, I mean, related question, but sort of change it a little bit. So, I mean, Antigoni talked about British effect. You also talked about British effect. So how EU law transmit to the other part of the world, particularly ASEAN. So my question is, to what extent has EU 61 affected legislation in ASEAN, particularly Thailand?
The EU ASEAN at transport agreement, as Antigoni mentioned, the consumer protection clause is something that the good things that the EU import to other countries, in addition to the environmental protection clause. But if we look into the clause, the template for the EU ASEAN one on consumer protection is quite similar to the EU-US air transport agreement that is mentioned, like we will cooperate on the consumer protection and then the joint committee. However, it unlike the EU-Canada air transport agreement, because for the EU-Canada, they will list the list of things that they would like to cooperate on consumer protection, such as the refund, the denied boarding, the accessibility for passengers with disabilities. So, in case of ASEAN, I think the EU know the nature of ASEAN as a regional integration organization, that they still leave the room for each ASEAN country to regulate its own consumer protection law. What I'm concerned is that the clause mentioned that they would like to cooperate to achieve the high level of consumer protection. And when we see the term high level of consumer protection, it reminds me of the CJEU when they try to interpret the 261 to benefit the consumer protection. Because in Thailand, we now have the aviation policy on consumer protection as well. But we try to, our purpose is to balance all stakeholders, say consumer and also the business. But with the high level at the ASEAN, but in our national law, we try to balance. But if we import the law, the black letter law, and also the decision from the CJEU that try to achieve the high level for consumer side, how can we balance with our national policy that we would like to balance? That's the at least one of the things that Thailand has to discuss and overcome this first. That's what my view. Thanks.
Okay. I still have a couple of questions, but I better stop. So Antigoni will handle question from the floor. Over to you, Antigoni.
Right, so please put your questions in the chat. I can only see one here. So please put your questions, draft your questions in simple English so that we can understand them. So there is a question by Abdullah Hussain, who says, hi, thank you for the presentation. You are most welcome, Abdullah. I would like to ask whether Article 5, Paragraph 2 of Regulation 2004, I believe you mean Regulation 261/2004, was the reason to not compensate passengers for the COVID-19 pandemic in 2020. So I think, Abdullah, you have invoked the wrong legal basis, because if you read Article 2 of Paragraph 1, 2 of the regulation, it provides that when passengers are informed of the cancellation, an explanation shall be given concerning possible alternative transport. I don't think you have invoked the right legal basis. If you mean what June mentioned before, i.e. That as per the regulation, if the passengers are informed at least 2 weeks before the scheduled time of departure of the cancellation, the airline has no obligation to compensate, if this is what you mean, and the airlines cancelled flights with due notice to passengers due to COVID-19, which I believe is an exceptional circumstance, then yes, then the answer to your question, yes, is yes. This is the reason why passengers didn't recover any compensation. And June sent me this question. Does the Montreal Convention make provisions relating to jurisdiction issues? Absolutely. Absolutely. There are 5 jurisdictions under the Montreal Convention, five bases of jurisdiction. So passengers can bring a claim to, and this is the 5th jurisdiction added actually by the Montreal Convention to the courts of the country where they reside, where they reside permanently. They can bring a case to the courts of the country which was the last destination, which was the destination of the flight. They can bring a case to the court in the jurisdiction where the airline has an establishment. They can bring a case to a court in a jurisdiction in the jurisdiction where they booked their ticket. So if you book your ticket in the UK online, you can go to UK courts, right? And you can also, I think I have mentioned 4 jurisdictions. The other one is related to the airline, where the airline is established. You look at establishment, you look at principal place of business, right? These are the 5 jurisdictions that we have under the Montreal Convention. Now, I cannot see any other question.
But Antigoni, maybe for that question you addressed, you're absolutely right for the applicable court jurisdiction. But I'm just guessing the intention of the question is more. I'm just guessing is about territorial jurisdiction and national jurisdiction. That question. So if I'm right, so what I'm trying to say, if it's something to do with extraterritorial jurisdiction, then my answer to that question is Montreal Convention doesn't say anything about principle of nationality, principle of territoriality. It's more about fundamental international law. So, if something happens in your own country, that country has right to legislate, right to enforce. But maybe issue related to our topic is that how is it possible that European Union exercise jurisdiction over the conduct happening outside of the EU done by non-EU? So that's the controversial part we raised.
Yeah, that's the extraterritorial application. It's another issue, though. Yes, jurisdiction, if the European Union has jurisdiction outside its borders, well, it shouldn't, as per international law.
Antigoni, while waiting for a question from the floor, I wanted to ask a question to you. So you said the that some company get commission at 50% success fee? Because to my understanding
Right.
it was outrageous. Can you explain more?
Okay, so there is a law firm here in the UK which is called, and incidentally, the UK still complies with EU air passenger rights law, because regulation 261/2004 is retained EU law. So there is a law firm which is called Bot & Co, which deals with 261 claims, and they operate on a no-win, no-fee basis. So basically, you give your case to them. You can go on their website. They claim that they have recovered 78 million pounds in compensation. Of course, more than 50% covers their fees. So they operate on a no-win, no-fees basis. They send letters to airlines, and they recover compensation for their passengers, and they are transparent with respect to their fees. So if you go on their website, they tell you exactly how much they will deduct based on how much you can recover. Now, of course, you understand that they assume a lot of risk, because at times they might decide to go to court. So they do not simply send letters to airlines. They may decide to go to court, so they have to pay court fees, and they have to pay to get expert reports, because the airlines may claim extraordinary circumstances, so they pay experts to get reports. And these reports cost £750. This is what they claim on their website, right? So they represent you in court. They pay for this sort of reports, and if they lose the case, you don't have to pay anything. If they win the case, they will deduct more than 50% of maximum €600 that you can recover, right? And there was actually, June, there was a case recently decided by the UK Supreme Court. So there is the case name is Bot & Co Solicitors and Ryanair. So basically, Ryanair changed its terms and conditions of carriage, general terms and conditions of carriage, and asks passengers, since I think 2016, it has been asking passengers to deal with the airline directly, to go online on the website of the airline if there is a delay, a cancellation, and fill in their information, and then Ryanair pays the compensation into the passenger's bank account directly. And Ryanair says that we are not going to deposit compensation into anybody else's bank account, and so then Bot & Co could not get paid. And it sued Ryanair, claiming that it has a solicitor's equitable lien over the compensations. And the case reached the Supreme Court, which said that, yes, indeed, the solicitors have an equitable lien over the compensations. And so if Ryanair wants to pay passengers directly to compensate, to deposit the money into travelers' bank accounts directly, fine, but it may be liable also for Bot & Co's fees, right? So there is some risk there.
Yeah.
And I see yet another question in the chat, but it appears that under the Montreal Convention, there is no applicable law provisions. Is that correct? What is the applicable law? Well, it is the Montreal Convention. We mentioned that it has an exclusive effect. That's Article 29 of the Montreal Convention, and some legal experts argue that the convention is also exhaustive, that it also has an exhaustive effect. So if something falls within the scope of the Montreal Convention, the Montreal Convention is exclusive. Hence, this preliminary ruling in IATA and DELFA as to whether Regulation 261/2004 violates international law, where the Court of Justice of the European Union found a way to reconcile the two systems by saying that they are complementary rather than contradictory.
And I see question, right? Another one.
I cannot see it in the chat.
Oh,
if they
okay.
have sent it
Oh,
directly to
sorry.
you.
I didn't. So the question I hear. So a question from the audience directly. But in Hong Kong, is overbooking not a deceit actionable in tort? I think there's an old English case to that effect. So good question. So this is one of the topic I didn't really talk in detailed manner. So remember, I said there are relevant law in Hong Kong, and under the TDO. There is a wrongly accepting payment in the trade description ordinance. So what it said is, if airline sell the ticket without intention, so they intend not to supply the product. So you sell the ticket, but you knew that you're not going to supply the product. Then it's a violation of TDO. But overbooking, normally what happens is that you were about to sell, you were about to provide service, but statistically they sell a little more than you can provide. So then at the last minute, you didn't provide your own, your airline didn't provide a seat. So in that case, it's not the deceit actionable in tort. It's more about, it happens, but it doesn't mean the airline is not liable at all. But that's not the scope of in tort. It's not the scope of the wrongly accepting payment under TDO. And also, to kind of follow up the question, the applicable law. So Antigoni, absolutely right. If convention apply. So that's a exclusive remedy under Article 29. I think if you ask me a question about applicable law provision in Montreal Convention is Article 1. You really need to see that which case convention apply. Then if it is under convention, then of course, like Antigoni said, only convention apply. Antigoni, by the way, your time is ticking, so please.
Okay, so indeed it's 10:28 in the morning here in London. Lalin, would you like to comment on something? Would you like to say something before we close the webinar?
Yeah, it's almost 5:30 here in Thailand. Yeah, so actually I think we see different approach among countries, and it's, for me, it's just there's nothing right or no wrong from any approach. And as you mentioned, the Korean one also interesting, that you get the compensation based on the fare. What I'm interested to see is how ICAO gonna take action, because for me it remind me of the environmental case, as Antigoni mentioned about the EU emission, and in the end ICAO need to pass the CORSIA in the end. Even we will not discuss whether it's effective or not, but at least in the end, ICAO need to take some action. So for me, I'm thinking that how ICAO will take action on these air passenger rights, because it's overlapping with the Montreal Convention, particularly on the compensation in case of delay. So I hope that ICAO can do something more than the ICAO core principles.
Core principles, that's right. Yeah, that's a very good idea, Lalin. That's a good idea. June?
Yeah, really, I'd like to thank all the audience who stay here. It's 6:30, and then it's a long weekend in Hong Kong. So I really appreciate the one who stay here. And also kind of the mission for us, things I wanted to discuss but couldn't discuss is about disability, the mobility with disability. So it's exactly Lalin's expert, but we wanted to cover, but maybe due to timely we couldn't. Maybe something that we can develop in the future.
Why not? Yes. Okay, so thank you everybody for your participation. Stay tuned, because next year's forum most likely will have a different format and will be more interesting than what you have seen so far. So stay tuned and see you next time.